In March 2020, Manuel-Ellis died while handcuffed in police custody. 3 officers involved in the incident are now on trial. Matthew Collins and Christopher Burbank are charged with second-degree murder and first-degree manslaughter. Timothy Rankin is charged with first-degree manslaughter. Thank you so much for joining us. I'm Christine Pei. For the duration of the trial, King 5 will recap the biggest developments in the courtroom, and we will discuss what it all means. Today, we sit down with retired Pierce County Superior Court Judge Brian Tollefson, also attorney Mark Lindquist, who served as a Pierce County prosecuting attorney for nearly a decade, and criminal defense attorney Sarra Marie from the Marshall Defense Firm and a former King County public defender. But first, let's take a look back at what happened in court this week. There's a lot to discuss. This week, we heard from the former Pierce County medical examiner who performed the autopsy on Manuel-Ellis's body. Dr. Thomas Clark ruled Ellis's death a homicide, but a piece of his preliminary report has also laid the foundation for a major aspect of the defense's case, which stated, quote, an argument could be made that the extremely high methamphetamine concentration should be considered the primary factor in Ellis's death. Clark's ultimate conclusion, however, is that Ellis died due to oxygen deprivation caused by police restraints. He said that while meth and an enlarged heart were contributing factors, he was able to rule them out as the main reason for Ellis's death, leaving him with one conclusion.
And I was confident enough at that time to use that information to say, then it must be the other thing. It's the physical restraint that led to hypoxia.
On the stand, Clark said he is even more confident now than he was in 2020 that Ellis died from hypoxia. Now, in the year after Clark made his initial ruling, he learned more information about the night Ellis died, including that officers were sitting and kneeling on Ellis's back, which supports his initial findings. Now, at one point this week, it was unclear if the state would even ask Dr. Clark to testify at all. And so we're going to talk about this. This is a very important point in the trial this week. Mark, you had mentioned that it would have been unprecedented for the state to not call the medical examiner during the trial, but after a series of objections by the defense, the prosecution had to shuffle their witness list. Let's take a listen at what happened here.
So are you saying that the state is no longer going to call Dr. Clark?
I never said whether we were going to call him or not, Your Honor.
Oh, that's news to me, Ms. Eakes, quite frankly.
I recall this was a little bit of a testing moment, this back and forth between the prosecution and the judge. Coming back to you, why do you think the prosecution was even thinking about not calling the medical examiner? Could you explain?
Well, it'd be highly unusual for the prosecution not to call the medical examiner, but I think now we have some sense of why the prosecution was waffling. Dr. Clark helped their case, but Dr. Clark also hurt their case, and he dropped a distracting bombshell, which is he said the prosecutor's office had pressured him to change his opinion. Now, Patty Eakes, who's the lead prosecutor, quickly pointed out that it was the Pierce County prosecutor's office that had pressured him, not the Attorney General's office, and it's the Attorney General's office who is prosecuting this case.
I do want to touch on one thing. We discussed this briefly earlier, directed to you, Sarah. One of the defense attorneys suggested that not calling Dr. Clark would have been what he called a confrontation issue. Could you explain what this means in legal terms and why they would have even brought that up?
Sure. So the confrontation clause is really talking about a defendant's right to confront the witnesses that are going to be called in the case and to confront the people that have made statements against them or are going to be used in order to try and prove these allegations. And so that's really what they're looking at here is what are the statements that he is making, but also what are the statements that he is looking at when he is writing his report, and whether he's going to be looking at statements that other people have made, the officers have made, and how he formed those reports and those opinions.
If I might add, I'm pretty confident that all the experts that have testified so far referred to Dr. Clark's report. So I mean, if he hadn't been called, that would have been a big issue.
Yeah.
So.
He was a foundation, and a lot of experts did refer back to the medical examiner's report. By the way, he's retired now from as Pierce County medical examiner. One thing that we do also want to address, the prosecution ran into a hiccup with several other witnesses, with the judge and defense questioning the need to hear from a pulmonologist who ended up being the third medical expert to take the stand. Additionally, the judge disallowed the former Tacoma Police Department chief, a police training expert from the Washington State Criminal Justice Center, and 2 police training experts from North Carolina, where Officer Burbank formerly worked, from testifying this week. So we're talking about a little bit of a musical chairs with the witnesses that we heard from this past week. Judge Tollefson, could you explain why a witness would not be allowed to testify in a trial?
Well, the judge has a couple of different factors that he has to weigh in making a decision on whether somebody testifies or not. First of all, there's the issue of relevance. Is the testimony relevant to the issues that are being presented to the jury? And even if they are relevant, the question is the testimony or the evidence unfairly prejudicial? Yeah. And so I think in his mind he was weighing all of that and trying to determine whether, number one, is it relevant? Number two, is it unfairly prejudicial? And I got the impression from listening to his ruling that he thought that this information, which he said might come in at a later stage. Sure. But at this point, it wasn't relevant enough, and he didn't say unfair prejudice, but he had to have been weighing that as a decision key.
And to be clear, this was sort of in the middle of the week when the prosecution was planning on bringing in the police trainer. The judge basically said that trainer would not be able to testify because there's one component that we needed to hear from, whether that had any bearing on how the officers were trained. What did you think about that interaction between the judge and basically, it was, in your words, Mark, you had mentioned that it didn't make the prosecution look that great when they had no backup witness after their police trainer was basically forbidden to testify.
Judges tend to get impatient when the prosecution doesn't have witnesses ready to go. So the burden's really on the prosecution to keep this show moving.
Sure, yeah. One thing we do want to address as well, going back to Dr. Clark's testimony during cross-examination, Dr. Clark explained that he only needs to be 51% sure of a cause of death to make a ruling, and he also said that might not meet the standard prosecutors use to make charging decisions. Mark, what level of certainty do you think that they need to bring a case to trial? And Sarah, do you think statements like this opens a door for the defense? We're talking about the medical examiner's certainty of whether it was hypoxia and a few of the other issues that he had laid out in his medical examiner's report.
Well, first, proof beyond a reasonable doubt cannot be quantified in a percentage, but we all will agree it's beyond 51%, well beyond that. Secondly, there was even a memo that came out in the testimony where there was an exchange where someone at the Attorney General's office said that they were worried Dr. Clark really wasn't going to help them prove their case because of his lack of real certainty about the cause of death. So that is probably, again, one of the reasons I think the prosecution was waffling on whether or not to call him. But in the end, they had to. They got him up there and they took what they could use, and the defense got some good use from it as well.
Well, what are your thoughts, Sarah?
I would absolutely agree. I think it's a very different standard for all of these different things, for what his opinion is going to be, for what the prosecution is going to use to charge, and of course what the jury ends up deciding. Beyond a reasonable doubt is something it's very vague, right? Yeah. It's something that almost every attorney has to figure out their own way of explaining to a jury, and it's always a big point in closing arguments. So I expect in closing arguments, this is something that's going to come up where they're going to talk about what is the burden that the jury has to look at, and it's not going to be that 51%. So absolutely the defense is going to be pushing on that at some point to say 51% is not proof beyond a reasonable doubt, and it opens that argument.
Right, and we heard from a couple of instances this past week. A lot of times the defense sort of spoke up and to oppose a witness from taking the stand. Could you explain, Sarah, how this benefits defense? You mentioned that this is sort of a strategy on their part, or whether it is even making an objection.
Objections are always a tough thing for the defense. Just like the prosecution, and I think Mark has talked on some of the previous shows about the obligation that the prosecution has to present all of the evidence. As a defense attorney, you're also always a little bit worried about, in front of the jury, being the person that's trying to hide things from them. And we don't want to do that. But of course, as a defense attorney, you also have an obligation to be providing the best defense for your client and worrying about things like making objections if things are going to be irrelevant or if they are going to be overly prejudicial. And so you really have an ethical duty to your client to be making all of these objections and preserving those issues and raising them in front of the judge to get rulings.
Yeah.
I'm not sure that fully answered your
Absolutely,
question, but
no. I mean, there's so many things to parse through. I mean, we kind of touched on the big elements of the people that we heard take the stand. But overall, to kind of open it up into a more broader sort of analysis, how do you think things are going so far, Judge? I'll start with you. I mean, we finished up week 5. It's been more than a month now. How are we doing?
Well, I get the sense that Judge Shushkoff is trying to narrow down what the prosecution is doing. I haven't seen this a lot in my experience. The whole idea about, you can't call those witnesses right now because that's not an issue that's before the jury right now.
Yeah.
That's to try and get this thing narrowed down. And the other thing is I've seen him ask different witnesses. He's kind of rephrased the question for the witness to answer. He said, well, he can't answer that question, but he can answer this. So trying to move the case along as fast as he can, because I sense that he's frustrated that it seems to be going a little on the slow side.
I got that impression from his tone as well while during the different parts of the trial this past week. Mark, do you think that it is a good thing that we're hearing from so many medical experts? I mean, we haven't only just heard from the medical examiner, which you say is key and pretty standard, but we've heard from a pulmonologist, we've heard from a cardiologist, we've heard from a lot of different medical experts. Is that pretty common and standard?
I would say it's pretty common for a civil case. It is not common for a criminal case, and I think we're very close to what I'd call overkill at this point with the jury. And as the judge and I discussed in a previous show, the jurors get an instruction that says you can ignore the experts. Yeah. You decide what weight to give them. And in the end, experts tend to cancel each other out. Now that said, Dr. Clark is an unpaid expert, and so he has some enhanced credibility because of that.
Sure. From my understanding, his cross-examination is not finished yet. I believe we're assuming that it's going to kick back up on Monday. What do you think the defense really needs to hone in on at this point with the medical examiner, retired medical examiner?
I don't know that I have a good answer to that.
Maybe further, because that's another thing we also know the defense might benefit from hearing from him too, so maybe honing in on perhaps some methamphetamine.
I think certainly pushing any of the issues that have come up relating to lack of certainty, bringing up the methamphetamine use, really bringing up any issues that are going to pull away from from all of the evidence that the state is presenting.
Absolutely.
The one thing, and I think Mark touched on this a little bit, that comes up with having multiple experts is you get cross ideas, if that makes sense. You get conflicting statements and you get conflicting ideas about what cause or manner, and even little statements that conflict, and so that may very well be a part of cross to bring up small distinctions between things, and again, just pulling away, pointing towards the methamphetamine use, pointing towards any other cause, and any other uncertainty that brings it down below that beyond a reasonable doubt burden, because it is a very high burden that they're not always opining to that level.
Certainly. Well, as always, such a great discussion and just sort of really kind of parsing out everything and helping us better understand this whole process. Before we go, though, do you have any final thoughts on how things are going? Anything else you wanted to point out that stood out to you?
I'd say it was just a rough week for the prosecution. They had one expert, for example, that tended to incriminate Officer Rankin, but tended to exonerate Officer Collins and Burbank. That's the witness who put the manner of death at Officer Rankin's feet. In other words, he was attributing the pressure applied by Officer Rankin as a manner of death. And Jared Osser, defense attorney for Officer Collins, immediately got up and was like, so my client was nowhere near Mr. Ellis at this time, right?
Right.
So now we're at that point where we've got a witness up there who's incriminating one of the defendants, but tending to exonerate the other two defendants. Now, that all said, rough week, but there are ups and downs in every trial. And as we've talked about, the officers are going to have to take the stand.
Yes.
Prosecution is going to get a chance to cross-examine those officers, and that's going to be more significant, I think, than any of this expert testimony.
Your thoughts, Judge?
Well, from a judicial standpoint, the judge is trying to move the case along. He's only going to make rulings if somebody asks him to make a ruling. So, for example, when the medical examiner made the comments about whether somebody was pressuring him to change his testimony,
Right.
you'll notice that nobody stood up and said motion, move to strike, because it was almost nobody. That wasn't his first comments about that were not in response to any question in front of him. So I was surprised that no defense counsel stood up and said move to strike, or even Ms. Eakes didn't stand up and say move to strike. It's like, but nobody did, and so the judge didn't have a chance to rule on whether it should have been stricken or not.
Right. Interesting observation. How about you, Sarah? Any final thoughts on how things are going?
It's an interestingly slow week, especially with the pauses. I think it was an interesting week for the judicial rulings, just in the amount of pressure on trying to push the case forward and things like that. I think certainly things are going to get a bit more interesting and a bit more exciting with some of the additional people coming up, because we're starting to see repeats and information that the jury has already seen. So it'll be interesting to see where it goes.
All right, Sarah, thank you very much. And our thanks to our entire panel today to parse this all out. We'll have more coverage of the trial coming up every Friday, by the way, and you can tune in on our streaming app, King 5 Plus, available on Roku, Amazon Fire, and Apple TV. Our weekly recap is also available on our YouTube channel. As always, you can keep up to date with our trial coverage on king5.com and on our mobile app.